I'm Heather Gilmore. I'm an attorney. I'm here on behalf of the Elder Law and Estate Planning sections.
Sorry. I'm Melissa May, and I'm also an attorney. I do estate planning, and I think I'm not necessarily representing anyone in a particular section of the bar here.
Peter Strauchel, Director of the Secretary of State Corporation Division, Executive Commission.
Tam Levitt. I am not an attorney, just to put that out there, but I represent the Oregon Credit Unions in the Capitol.
I'm Amy Defco, and I work at the Oregon State Bar.
Lane Shetterly, Chair of the Oregon Law Commission.
Sam Dupree with the Oregon Judicial Department. I work in the Office of Policy and Education as an attorney.
Well, thank you all, and thank you for volunteering to be part of this thrilling work group. We get to change the law again.
There's one person who didn't introduce themselves. Rochelle, are you there?
Yes, I am.
Would you like to introduce yourself?
Or not.
Or not. Okay. So I will turn it over to Lane.
All right. Thank you very much. I just have a few words of welcome, really, on behalf of the Law Commission, thanking everybody for participating. I think a number of you have served on work groups before, so you know the protocol. The Commission has approved this work group, formed this work group for the purpose of the revised Uniform Notary Act relative to the changes around remote notarization. I say that because I think there's been some interest expressed in going perhaps beyond. I know Cleve was interested in, or PURA, which is electronic recording of real estate documents. That's a very interesting subject, and I would like to address that at some point. The charge of this work group is narrow to remote notarization. So keep that in mind. We're not going to be getting into the general notary statutes in this group. If you have recommendations that we would take back to the Commission for some additional work on that, we would consider that. But for this work group, remote notarization really is the subject. I want to thank you for volunteering. One of the strengths of the Commission is the volunteer hours that lawyers put into the work that we do. Your work will be, when you're finished, your work will go forward to the full Commission for review, and assuming that it results in a bill, some form of remote notarization, preferably around the Uniform Act, then the Commission would move that forward to the legislature. If you get your work done in one meeting, well, we can get it in time for this legislative session. If it takes a little longer than that, we may have to postpone this for another legislative session. I don't think it's urgent, but we are interested in getting this done. My sense is, and Peter probably knows as well as anybody, and Michael on the phone, who is part of the Uniform Law Commission Drafting Committee, probably knows as well that remote notarizations is one of those brave new world things that's happening, and we need to figure out some way to accommodate that as much as anything. That's just my sense of the way the world is moving. So with that word of welcome, I'll turn it back to you, Mr. Chair. I will also apologize for leaving early today. I've got 2 other meetings going on in this building that I'll need to break away to attend to, but I wanted to be here for at least the start of this work group meeting to thank you again for your service to the Law Commission and to the state, and to welcome you.
I know at least one person joined on the call when Lane was talking. Would you like to introduce yourself?
Yes, hello. My name is Timothy Reiniger. I live in Maine, and I have been appointed by the American Bar Association as one of the advisors to the Uniform Law Commission's efforts to amend the RLUNA. So and I've been asked by various interested parties time to time to participate in the states as they were looking at adopting these amendments and online notarization in general. So at any rate, I'm delighted to be sitting in on this call and providing any assistance I can.
Welcome. Thank you for joining us.
Very welcome. Thank you.
Thank you.
And Tim, Michael O'Neill is also on the call. Very nice to talk to you again. Tim is being very modest. He was one of the pioneers of remote notarization in Virginia earlier this decade. So we've got a heavyweight with us today.
Oh, thank you, Michael. But along with that, by the way, is we now have had, when Virginia did it, it was the first. There was no models or anyone to look to. We were just coming out of the blue with it. And now, though, we have the benefit of many states doing it, the experience of many providers. So we have a lot, as you all go through this, have questions. We can point to things that haven't worked, things that have worked, and put Oregon in a position to have a really good bill.
Great. Thanks very much for your participation, and we'll call on you for history and where not to go, hopefully. The genesis of this bill, or this concept, was really to at least look at the fairly recent Uniform Act amendments that came out earlier in, I think, 2018, and see how the amendments may work or not in Oregon, because we are rather a large state, and the potential for remote notarization does provide some, I guess, interesting aspects if there are the safeguards. And we kind of talked about some of the safeguards that we'd be looking for, and that really revolves around making sure that the verification of who's signing what is taken care of and can be memorialized in a fashion. The Oregon statutes are in Chapter 194, and they were last revised, I think, in 2013, that allowed for the potential of electronic notarization, just not remote notarization. So maybe we can have our esteemed callers identify kind of the background of why this has been proposed by the Uniform Laws Group, and what history has been with other states. So Tim or Michael, tell us why we
Sure, this is Michael. I'm happy to start it off. Remote, as Tim was mentioning, remote notarization was basically invented from scratch in Virginia back in 2011. And for many years, it was the only state that had a law like that on its books. And as you will probably recall, one of the reasons for lack of momentum in adoption of electronic signatures and notarizations was we went through a very terrible recession, where many of the folks who would otherwise be interested in these new technologies and adopting them in the real estate, elder law community, mortgage communities, were very busy doing lots of other things. But what has happened over the last, I'd say, 3 years or so, is a renewed focus by lots of industry participants to adopt remote notarization and use electronic processes and transactions. And people then started taking a really hard second look at the Virginia law to see if this was a model that would work for the rest of the country. And the Virginia law, as Tim was saying, was a sort of invented it from scratch and came up with some really good ideas about how to do this in a safe and secure manner. Although one of the downsides of the way the Virginia law works is that it puts into the statute a couple of documents and basically federally used procedures for example, for people who work in the federal government as contractors in Northern Virginia. And it didn't create what I would call a really broadly flexible framework to use different technologies to identify folks who are doing remote notarizations over time. So that was one of the real key things that was focused on, was how can we set up a law that defines the process of identifying somebody using technologies in a broad way that is neutral and that will not become obsolete in 5 years' time. And that was one of the core things that the Uniform Law Commission focused on. The second question was, how can we define technologies in both a neutral way, but also in a way that will provide confidence that a remote notarization is at least as secure as when you identify somebody in person today. And there is a lot of thinking in the field of authenticating someone in an internet context. Technology industry is worked on this problem for decades. But essentially, the key feature to identifying somebody in a remote context or over the internet is to use what in technology lingo people call multi-factor authentication, which essentially is a big way of saying that you need to have at least two different processes or two different ways to identify somebody technologically. And if you think about how you identify somebody, or how you can securely identify somebody, there's really only three options out there. You can identify somebody through something that they have physically in their possession. That's the way we do it whenever we ask for a driver's license, or somebody has a key, for example. Or you can identify somebody through something that they know, their knowledge, and that's how you identify somebody, for example, using a password. And then finally, you could identify somebody by something, what they are physically, biologically, by their traits. So biometrics, and it was kind of the new cutting edge field for identification in as people are trying to figure out ways to deploy biometrics securely on a commercial scale, although that's not really, I wouldn't call that present day reality, except in some limited context, for example, biometric passports. But essentially, multi-factor authentication is simply a way to say you want to require at least two of those three things together. And when you combine two of those three things together, you make it extremely difficult, if not impossible, to fake somebody's identity or fraudulently claim an identity. And kind of the easiest example, if you want to think about how multi-factor authentication works in a real-world context, I like to point to how we use ATM cards today. An ATM card is a physical object. It's something that you possess, but it also has to be activated by a password, something that you know. Now, an ATM card doesn't have your photo on it, but if it were, and it were specifically linked to you, that ATM card would be a really great way to authenticate somebody in a remote or electronic process. Someone who steals your wallet is not able to access your bank account because they don't know your ATM. Or somebody who manages to, if you're like me and are silly enough to put your passwords in a secure file somewhere, if someone were to get access to that, they still couldn't get access to your bank account because they don't have your ATM card. And so multi-factor authentication is saying, let's combine two different technologies or two different processes in a secure way. And that has been, I think, the single aha moment with remote notarization. If we can enshrine that concept into a statute and then allow the commissioning official, the Secretary of State's office, to promulgate regulations that will specify different types of technologies that can be used over time, you both have a secure statutory framework for identifying somebody and one that is flexible over time and allows notaries to use different technologies that come online. That was really the core mandate of the Uniform Law Commission, is let's solve this from a legal statutory standpoint. Let's not be overly prescriptive as to specific technologies. And as you probably know, there are at least a dozen states that have already enacted RULONA, the Revised Uniform Law on Notarial Acts. And so the other mandate was let's create an addition or a plugin that will work with the rest of Rulona, work with those provisions of Rulona that allow for electronic signatures and documents, that any state with Rulona on its books can use our model. And in fact, what I've been kind of encouraged about as remote notarization has really, I'd say, swept the country the past 18 months to 2 years. We're seeing legislation in more than 24 states being introduced this year, is a lot of states are actually looking at not just adopting remote notarization, but specifically looking to adopt Rulona, which Oregon already has, and using this uniform model as really the best in class uniform law out there. That's really the broad intro, I would say. There's a lot of specific details we could get into, but that was the ULC's charge, and it's not a very long amendment, but it's I think a very powerful and flexible one, and you will see that it leverages a lot of the existing things that Oregon already has on the books in its notary statutes.
Great, thank you.
Mr. Chair? Yes. Michael's comments were excellent, right on the mark. And one big point I would add is a major strength of the Rulona and a major focus of the ULC for the last century has been interstate recognition. And so that, while it may be obvious to many of you in the room and all that, that has been a big legal question with respect to remote notarization from the beginning, and it's a source of some opponents or critics looking at this. And so I just want to build on Michael's comments and say that it's been an outstanding benefit of Rulona, and to preserve interstate recognition, to preserve that regime that has been in the paper world with material acts. And that was also a focus of this drafting committee, to make sure that in the amendment efforts that there would be no disruption or veering away from that interstate recognition tradition for notarial acts.
Great, thank you.
Can I ask a question?
Go ahead.
I was just wondering if you could talk a little bit more of the opposition that you've seen around the country and other states, and what kind of issues that they're bringing up.
This is Michael again. I work on a lot of this legislation around the country, and as you can imagine, there's lots of different constituents that are interested in it. I would say that there's not really what I would call opposition per se. There are questions, sort of persistent questions that get raised about remote notarization when folks are not being introduced to it for the first time. The best way to really learn about how the process works is to see it in action. And so for a lot of the questions that people have about how does this actually work in practice and can it be secure, until you actually see it in practice, it's kind of hard to visualize a lot of the moving parts of it. Politically, opposition, I would say, comes in two flavors. One is commissioning officials who understand that they want to support this technology, but they're strapped for resources, and it does require rulemaking in order to implement and specify the technologies that can be used. Now, you will see that the ULC version does not require rulemaking. It says that the commissioning official may adopt rules for these various procedures, and that was done, as you'll see in the drafting committee notes, intentionally so that a law won't be passed and then not become operational because a commissioning official doesn't have the resources to actually promulgate regs. In some states, we've seen fiscal notes get attached to this, where they say we might actually have to hire a new staff member in order to work on all of this. But that has not been the norm, I would say. And I think the concerns about how this can be implemented have greatly receded over the last 6 months or so, given that the next generation of states, Texas, Nevada, and Minnesota, and soon to be Indiana, have all adopted or have almost finalized regulations that are really an off-the-shelf solution that other commissioning officials can look to. So that has been really a persistent conversation. Whenever this gets introduced, the Secretary of State's staff, first question they ask is, how are we going to do this? The other opposition, I would say, is coming from the title industry. I say this as someone who, my default mode of new technologies and new processes is profound skepticism. And I think that we in the title industry, because we bear a lot of notarial risk, whenever we insure mortgages and deeds, financially, we probably assume the vast majority of all financial risk with notarizations and invalid notarizations in the country. We've been extremely cautious over the years before adopting this. And it really is only because of the processes and the safeguards that the ULC draft and our own industry model, which is frankly based on the ULC draft. It's only in the last year or two that I think the title and mortgage industries have become far more comfortable with remote notarization. And so that other corner of opposition within our own industry is quickly turning. I would also add that I think that the technologies that are being used to identify people with remote notarizations are superior to what you traditionally rely on in an in-person notarization. And I would not be at all surprised if the technological processes for remote notarization even start to bleed over and get used in in-person notarizations, traditional notarizations in the future, because really when you get down into how multi-factor authentication works in practice, it provides a superior and more secure and more fraud-resistant way of doing notarial acts. So once that policy question was resolved to our industry satisfaction, I think you've seen a rapid change in attitude from the title and mortgage industries to this.
Okay, a follow-up. Michael, this is Heather Gilmore. I'm an estate planning and elder law attorney. I think that one of the questions that I have, and I'm interested in how other states handled this, was when you have in-person notarization with an elderly person on something like a power of attorney, you can see physically the impact that the person standing in the room with them has on the elder's decision to sign or not sign, or the ability of the elder to comprehend what they're doing. You can see if they're being led, you can see if they're being strongly forced or informally forced by facial and hand motions. Are there any states that have protections that have included that concept?
The states,
like I can stand behind my mom's
would,
iPad and tell her, you have to sign this, but I can use my lips to say that, and you can't, the notary can't see me.
You will not be surprised that the states where this discussion is most advanced and has been hashed around most is Florida, with a very large elderly community. But of course, lots of other states are extremely concerned about this issue as well, and it is a recurring one. I will say that there are, you accurately identified the problem is you can use technology all day long to make sure that someone is who they are. In other words, it's not a fraud or forgery, but how do you use technology to detect undue influence and coercion? And how, when a notary interacts with somebody over a webcam, is their situational awareness going to be diminished? Because obviously it is, compared to being in the room with somebody. And so there's no technological solution to that particular problem in terms of getting situational awareness. What you can do are process tools. And this is part of really sound notarial process for remote notarizations. So you want to have a conversation with the person. You will have the signer move the camera around the room to see who else is in the room with the person. The notary should identify whomever else is in the room with the signer. And the other thing is that the signing event is recorded, and a archived recording is kept by the notary. And between identifying everybody in the room having a conversation with the person, recording the signing event. You were trying to claw back as much of that awareness that you were describing about physical witnesses into a remote signing as you would have with an in-person signing. The states who have addressed this are starting quickly to adopt, and not just powers of attorneys, but even the trend today is for remote witnessing of wills and codicils, creating testamentary documents. And Nevada has already authorized the electronic notarization and remote notarization of wills using their remote notary statute. And indeed, the Uniform Law Commission is today working on an electronic wills act that would allow for remote witnessing of wills. And so what I think has happened is, as people have watched these signings, the elder law attorneys who have these concerns have seen demonstrations, witnessed it, understood the power of having a recording of the signing event. I wouldn't say that those concerns you've raised have disappeared, but they've been dramatically mitigated by these different processes that are part of a remote notarization.
Have any of the states adopted administrative rules that require the notary to engage in the safety practices, like identifying who's in the room? And I'm just kind of curious.
Yeah, that's a real, you will notice that Rulona itself requires as a statutory measure that a notary have satisfactory evidence of identity, but it does not set up a standard of care for determining capacity, which is largely has been a common law tradition in our notarial law. It's not been one that's been addressed by statute. And Rulona was very deliberately drafted not to try to create a new statutory standard of duty of care to determine capacity for the notary. So this has traditionally been an area that has been left to things like codes of professional conduct and ethics and training. And as of today, there are no states that have actually put those types of standard of care into a regulation. And I think that is largely because there's been a hesitance to create an actual bright line duty of care by regulation or statute in this entire area in notarial law to date. I mean, it's not something that is governed by statutory duties of care. It's one that's governed, again, by common law principles of negligence. So that's why no state has done that. But I think it's a deliberate choice not to try to change the fundamental framework of notary liability.
Thank you. Peter?
Yeah, I was mostly, she asked the question is around, are there any other statutes or requirements around competency and that's, kind of where, we see, not so much around identification that's used or the problems that come back to us as doing regulatory activities over notaries. The questions always come back to the signer wasn't competent, the signer didn't know, was coerced into signing. And those are the claims, and a lot of times, in those situations, the signer has passed away, and so now it's a will type of an issue, or there was property transfer, and so it gets very contentious.
And the difficulty of relying on negligence of the notary is this: they're judgment proof. They're, unless it's like a lawyer or some professional, the girl at the bank has no recollection of the circumstances. I mean, I'm talking about in-person notarization. You can't, the horse is out of the barn. Aunt Susie's money is gone with the power of attorney. And so, from my perspective, I appreciate that you don't want to have a bright line about what the standard is, but in Oregon, I think we might want to consider a bright line because elder abuse is rampant.
Yeah, maybe some protections for people over a certain age or certain transactions, specifically like a will.
Yeah.
Because, people show up at the UPS store and the notary on duty is an 18-year-old that just got hired who just became a notary 3 months ago, and the document that's being presented, they've never, had any experience with it. And so, we do require education and training for new notaries, but renewing, if you've been a notary for a while, you don't have that requirement. And so it starts to get into those issues.
Yeah.
It's important to keep in mind that we're talking about an issue that exists today with traditional notarial law. And the question really is, with remote notarization, are you increasing the risks in some sort of substantial way that would require a different framework than how we're dealing with it? And I think broadly the answer to that question has been, when folks have focused on this, is no. And in fact, remote notarization probably reduces the overall risk, because the person passes away or disappears, but there is a recording of the signing event that is retained by the notary. And so you actually have greater tools to prove or disprove capacity or authority issues after the fact than you would with an in-person with the guy at the UPS store who may or may not have even filled out his notary journal.
Follow-up, Peter?
Yeah, just kind of a question on that. That's, one of the areas that we have some, I guess, questions that the Secretary of State is, who is, right now, the notary keeps their journal, and presumably an electronic journal, they would keep that as well, or is that a subscription service that's, on the internet, in the cloud? Where are those recordings kept? Are they kept by the remote technology companies? And does the notary have access, or does the notary need to download copies of those to their own PC or their own Google Docs account or something? So it really comes down to that possession and kind of thinking out what happens when, one of these remote technology companies goes out of business 5 years from now or 10 years from now, then, and they're, all their thousands and tens of thousands of recordings, where do those go if the company's out of business?
Yeah.
Those issues, of course, have not been put into a statute, but they have been are an extremely appropriate area for rulemaking to take place. And one of the things you'll see that this Remote Notary Uniform Law Commission draft does is it specifically drops that whole thing, the question of retention and designating repositories, into a rulemaking bucket. The state that has grappled with this most successfully to date has been Texas, and with their regulations that they issued last summer. And they require that a notary may enter into a contract with a third-party storage provider, but that the contract must specify that the notary has unlimited access to it during the term of the contract, and the contract must last at least as long as the retention period, or the contract must specify that if it is terminated, the notary will have access to the materials after the termination of the contract. So when the outside question that you raised is, well, what if the vendor declares bankruptcy? Well, presumably, the information is accessible somewhere on a cloud. But the way that it is done today is, these are largely cloud storage-based, password-protected storage providers. But a very good practice is to have a notary retain a backup, a physical password-controlled, password-protected backup of those records too. And so the Texas regulations add that into their requirements as well. Now, it doesn't specify how often the notary must back it up. That's something that's sort of left vague. But putting those types of requirements into the regulations for what these storage providers must have in their contracts and what a notary must be able to have access to and what they must back up is an extremely smart idea. The more, I say, hands-on approach is the one that Michigan is currently wrestling with. Is they're trying to take the approach that we will in advance approve what specific platforms can store these things. And so they'll come up with a list. And I have no idea what thought process is going behind approving these vendors, whether they're looking at financial strength or what. But that is a possible additional approach that could be taken.
Okay, thank you. I've got a question that may be just a straw man, but let's go with my hypothetical here. As most people face notarization, it's in the closing of a real estate transaction. So if a closing is to occur in this transaction, if the title company decides that they are going to set up a national call center, and I'll just pick the bogeyman of Plano, Texas, and that happens to be a state that has remote notarization, can a group of notaries under Texas law remotely notarize the real property transaction that is occurring in, let's say, Ione, Oregon, a small little burg out there, and what jurisdiction would the Oregon Secretary of State's office have to regulate that notarization under Texas?
That goes back to what Tim was mentioning earlier about the long-standing tradition of interstate recognition of notarial acts that we've had in this country going back, frankly, before our founding. If you go back to the early statutes passed in Massachusetts and Virginia, as I have done historical research in, you will find those types of interstate recognition statutes well back into the 1700s, and continue today and are part of existing Oregon law. And so as a practical matter, Oregon law recognizes notarial acts performed in the authority of other states already today, and there is no oversight authority by the Oregon Secretary of State, for example, over notarial acts performed in those other states. It's part of our broad legal tradition of interstate recognition. And so one of the things that is really driving adoption of these statutes around the country is just the dynamic that you mentioned, is that these things are happening all day, every day, today, across the country already. And there are countless thousands of Oregon residents who have already performed remote notarizations on documents using other states' notaries. And so the question becomes, in that context, without a remote notary law on the books, that you are almost forcing Oregon residents to use other states' remote notarizations whenever that's the option they want to go with. And so the answer is today, no, there is no restriction anywhere on this type of transaction of using other states' notaries for different purposes, including real estate closings. Now, I will say that the different title underwriters who insure transactions are taking largely an extremely conservative approach to this question. And so the correct legal answer might not be the practical answer in the marketplace today, but that's certainly the direction that things are going.
If you use that scenario, though, Mark, that's a good scenario. For my concern is that I could use my mom's iPad and call up a notary in Texas. They have no idea what my mom's capacity is. They have no idea what I've done to make it so that she answers the questions. And then how am I going to sue that Texas notary? I don't have any recourse. I might not anyway, but how, really, that makes it even more difficult. And it makes it more difficult to get the records.
Well, exactly. And that's why I raised the jurisdictional issue. Hopefully, to have other states, shall we say, input on how they deal with that kind of situation, or if it is a problem at all. Because I think it is germane to the discussion here. And hopefully we'll have some guidance and can discuss that and decide if this is a good idea or not.
So I think,
Peter.
you know, in our research, Montana is the only state that's limited remote notarization to acknowledgement. And so, that, does kind of limit it more to those real estate transactions. Somebody's borrowing money, there's, some financial relationship there, a loan application, that sort of thing. So it takes it away from a lot of the other abuse that you might see in wills and other, maybe a deed transfer.
Powers of attorney are only acknowledged, they're not subscribed, sworn.
So Montana is currently adopting what you are looking at on the table. They are also a Rulona state, and they did pass their own customized version of remote notary law back in 2015, and it was a highly restrictive law. In fact, it didn't even allow the use of technological means of identifying somebody. The notary had to personally know the signer. So the law that's currently on the books in Montana is going to be replaced this session with basically what we're looking at here on the table. The question of capacity for will signings is one that I think should be taken more off the table at this point, and that's because electronic signatures and electronic records for wills are already excluded under Oregon law, both under the exclusions and scope of the Electronic Transactions Act, but also in your statutes for the formality of will signings. That has been a policy decision that was made basically nationwide about 20 years ago. And so I think there is still a lot of caution to jumping into using these technologies for signing wills. Although, as I said earlier, Nevada has already authorized it, and Florida is currently working on a remote will signing legislation, and so is the Uniform Law Commission. So that is coming, I believe, but it is not part of this law.
It's not a real protection in Oregon for two reasons. Number one, we no longer have a mandated witness or notary requirement for wills. Number two, if you look at the Electronic Signatures Act in Oregon, it only excludes wills and testamentary trusts. It doesn't exclude powers of attorney or revocable living trusts. So those are challenges for us in a real sense.
One other question about experience in other states. Has there been any difficulty in getting an electronic a record that is electronically notarized to be able to interface with a court record, electronic record system? And maybe I'm not speaking very clearly. What I'm concerned about is if we've got a need to have an electronically notarized document in the court proceeding, how can we get a document that is, shall we say, able to be converted to PDF, which I believe is what the courts require for electronic records? How does that work under this proposed language?
Are you talking about just the admissibility of electronic records into evidence?
Admissibility, I'm not all that concerned about. What I'm concerned about is having a record that is consistent with what is required by courts, and usually that is a PDF kind of image.
So I can explain this, I think, a little bit. So Oregon has an e-filing system where you can file into the case register. Right now, we require a flat PDF in order to e-file because of some of the things it does with our system if it's not a flat PDF. So if you have, I'm sort of certification behind the document, and it's a PDF. Sometimes we can't make it text searchable, or that also has some ADA implications.
Oh, I see, like a smart PDF, for example, might not get accepted. So the end product of a remote notarization, it's important to keep in mind that the only thing that this amendment adds to your notarial law is the use of a webcam interaction and identification processes. The electronic record itself that gets produced is being produced under your current notary law. So if a notary is currently doing electronic notarizations in Oregon, using electronic signatures and seals and creating tamper-evident documents, that would be under your current statutes, and this just doesn't touch that or add to it. So if there is a formatting issue where, for example, a tamper-evident smart PDF has to be converted to what we would call a dumb PDF for purposes of being uploaded to a particular system, presumably that has to happen today and is happening today. And this proposal doesn't even address that because it's just building on your current foundation.
Okay.
Does that mean we can print it and scan it?
If current, you'd have to look at your statutes, but if current statutes or processes or regulations for whatever filing system allows that, then yes.
And I will say
this doesn't affect this bill does not affect the universe of how electronic records are created, stored, received, or admitted under state law. It's all of that's in place.
And with the current PDFs that do have certifications, there are ways to strip them of the certification. I know a lot of attorneys are doing that.
I know for land record submissions, most states don't even accept PDFs. They require TIFFs, which are literally just like photographs or photocopies of a smart PDF. And so by necessity, you do have to strip all of the metadata out of the PDF to make it recordable. That doesn't mean you don't retain the actual tamper-sealed metadata PDF in your file, but just as far as the file formatting that gets submitted for recording into the land records, that does get converted to a TIFF at the point of submission. So I could talk way more about land records than other types of filings for obvious reasons.
I appreciate that, and Heather, you've got.
I was just going to say, I actually like the idea of remote notarization, but I want to make sure that we have some protections. And so I don't want to necessarily be Montana where we're unworkable, but at the same time, I don't think that we just say, okay, we'll take it lock, stock, and barrel. I think we need to have something more. And we're Oregon, and we're used to deviating from the standard.
So you will want to follow some bills that have been recently filed in Florida, where this issue of, particularly the issue of powers of attorneys, have been hashed out with the Florida bar most vigorously over a 3-year period, I will add, because they have been extremely focused on the exact issue you've raised. So I can send that to this group. Essentially, they are allowing the use of remote witnessing, but they're providing kind of a specific statutory framework for it in the context of powers of attorneys and wills.
Right. Yeah, Michael, thank you. This is Sandy. You have my email, and just anything you send to me, I can get out to the group.
Peter, you have
Great.
a question?
Perfect.
Yeah, it's just, I guess an observation, maybe a question. As I've gone through the Model Act, certainly there's the combination of the electronically signed and remotely notarized document, where that's all happening at the same time. But there also appears to be the possibility for documents to be pre-signed by the signer, scanned to the notary, and then it's notarized after the fact. So that, which is, very different than the environment we have today, where everything happens in the physical presence and all takes place at one time. But, you then have, the notary saying, is this the document that we're gonna notarize? Is this your signature? And getting that confirmation that it's recorded. That is a big departure from how things are done today. Okay? And that seems to be
that particular framework was kept in the uniform law because that is part of how acknowledgement law traditionally, unlike an attestation of a signature or a jurat, an acknowledgement is the act of acknowledging that you have signed a document to a notary, rather than the act of the notary witnessing you sign the document. And so the actual signing could have taken place months or years prior. The acknowledgement is still valid. And so that's what the Uniform Law Commission is recognizing there, is that they're not changing the nature of acknowledgement law in the U.S. And a consequence of that would be, yes, that a previously signed paper document could be acknowledged remotely to the notary public by the signer. But it does require that the notary use reasonable means to confirm that it was the signer who signed the document and it was the same document that they're acknowledging. So again, the idea is that when we were thinking through this, we didn't want to somehow change the nature of acknowledgement law. But I would imagine that would be a fairly rare use of this type of technology.
Peter, you have another?
Yeah, just with that, how are other states handling the process of the signers selecting the notarial act and not the notary selecting that on their behalf and basically crossing into legal advice?
Michael or Timothy, did you hear the question?
It's about the type of notarial act appropriate for a document.
Did you make
where the sign? So how are other states handling the signer selecting that notarial act versus the notary recommending a notarial act for the signer?
It's handled the same way it is, I suppose, today under notarial law, which is it depends on the form of document and the form of notarial certificate appropriate for the type of document. In most cases, documents will have sort of pre-printed certificates. But if a document does not have a pre-printed certificate, just like today, where the notary has to discern what type of notarial act the signer intends the notary to perform, you would have to under this as well. There's no change here into how notaries have to handle that type of situation.
Peter, are you talking about like LegalZoom sets up a notary, a remote notary, and prepares documents and then has the LegalZoom documents notarized? Is that?
So, in just my own example, a few weeks ago, we're transferring a brokerage account from one brokerage to another. It's all done online. We print out the document and, we go take it to a notary, and the notary says, well, what kind of certificate do you want to do? And they pull out, here's, 5 different ones you can do. And it's up to me to pick which one we're going to use. But, somebody who's the administrator of the state notary program, and, I had a lot, more knowledge about what to select. But the general public, when first presented with this, they're like, I don't know, can you help me? And, we really counsel notaries not to, that's the signer's decision. You can't make that for them because now you're going into legal advice.
Yep. Cleve?
Yeah, that's a traditional area of concern for all notarial law, I believe.
Cleve, you've been pretty silent out there from the title companies. Do you have any concerns or thoughts?
Well, the one concern I'll mention is this other issue of recording and as well as notarization, because right now Oregon has not adopted as Lane mentioned, the Uniform Real Property Recording Act, and as a result, I think Oregon is in a situation where if you're doing a signing and everything's digital, Oregon does not have the statute to authorize you to submit an electronic document for recording. And I think those that are parties that are lenders and so forth who are interested in making electronic signing available to customers, you couldn't really do that right now because of the way our recording laws are set up. And Michael is aware of this. He's helped us think about ways to adjust for that. And in fact, the Model Act that the American Land Title Association and the Mortgage Bankers Association developed has a couple of, sometimes statutes have some effect on existing laws. So as part of integrating the new with the old, you have additional sections in your bill, and the ALTA MBA Act has a couple of those, so that if we enable the remote notarization, which is a form of electronic signing, I think, that these add-ons would integrate the recording statutes in with the electronic signings that the notarization bill will enable. So that's, I think, to get the full benefit of the notary bill or notary adjustment, you've got to deal with the recording issue, because a lot of these questions relate to real estate transactions where recording is necessary. But otherwise, you know, with Michael and I have talked, and more, he's lived with it longer than I have, so he's really the expert, as I think you can tell from responses to the question so far.
Yeah, great. Ken, I'm going to put you on the spot if you're still out there. What do the bankers think about this concept?
Well, we're still very much in the learning curve, and I think some of the concerns that have been expressed, particularly about you know, knowing that the notary's ability to know that the person who is signing the document is not acting under duress, undue influence, or other circumstances that would be inappropriate. That's a major concern for us. You know, I actually went to a presentation last fall on this act compared to the LTA MBA draft, and my understanding is they're quite similar, but the proponent at our meeting was actually one of the co-chairs of the drafting committee for this thing, so he was pretty strongly in favor of adopting the format. But I'd say at this point, we're just trying to figure out how this would impact the notaries that we have on our staffs, and I don't, other than the concerns about making sure that there's not undue influence, et cetera, I don't think we've really formed any opinion about it yet.
Ken, and I'm directing this to you as kind of the banker expert here, but also to Pamela. Have you thought through how a protest to commercial paper would work under this kind of remote notarization? Because though I've not had to protest an instrument of commercial paper, I think that, you know, that's something that notaries could do, record a protest. Peter's got his hand up, so I'm going to ask him.
Yeah, funny you should mention that. A number of years ago, Oregon law was restricted so that protests on commercial paper can only be done by the notary who's under the direct supervision of a financial institution, so a bank, a brokerage firm, those types of organizations. Just a general notary out in the public, you know, doesn't have the authority to do it.
Okay, well, then I think to Ken and Pamela is kind of an appropriate question, maybe.
Actually, Hal, can you take that question? He's customer. Hal, are you there?
Yeah, and I guess I would just say from credit union's experience, that happens so rarely in the credit union world that it's not their primary focus on this particular topic.
I think that's true for the banks as well, although we do see it more frequently. But this is not, commercial protest is not something that we've focused on at this point with respect to this bill.
Okay. Any other questions or thoughts about just the concept? Other than, yes, we need more information, a little bit more.
Well, I just wanted to say, I don't know how many of you know, but I introduced House Bill 2425, which allows the county clerk to record electronic records for e-signatures. So that bill will be heard probably in a week, and our folks don't like the law. There were a lot of gray areas in the law, and we wanted to make sure that the statute was very clear. We purposely did not address the notarization issue, knowing that the Oregon Law Commission has been a leader in this issue. I mean, I think our members would have said, let's go down that road. And Hal and I were like, okay, well, let's hold on. There's a lot going on nationally. We understand, Cleve mentioned the Model Act. There's been a lot of work done on this issue, and we did not want to get ahead of the curve on the notarization issue. But we thought this session it would be important to clarify electronic, the wet signature issue of mortgage documents. And so I've been talking to a lot of legislators. It's interesting, a lot of them have had personal experiences where they've been out of the country and had some problems trying to get back for signing mortgage documents. But also from a credit union perspective, we are very clear that we want to make sure the protections are in place. Elder abuse is a big issue for us. We see it every day in our financial institutions. And so we want to make sure that anything we do, and we're very supportive of this discussion, very supportive of remote notarization. We just want to make sure that we all talk about kind of the safety and soundness and the security and elder abuse issues going on out there, and write something that works. So I have been talking to legislators about this issue. I said it's kind of coming, but there's lots of discussions going on, and we're just kind of happy that Oregon is finally having this discussion.
Okay. Anyone else on that arcane topic of protests of commercial paper and things like that? Daddy, we're going to need to follow that other bill. I see that we've got something going on.
I have a note, so sure.
And if you have any concerns about it, let us know. We did have a meeting with the mortgage bankers and brokers in the county and clerks and land and title companies in December to talk about it, and I have not heard any opposition. So there is concern, especially for the commission. We want to
Mark said, on behalf of the commission, I'll follow that bill.
Yeah.
And,
Pamela, have you had participation from the county clerks or the reporters in your bill for recording standards?
Yes. Well, we had one initial meeting, and I will tell you they were the most enthusiastic about moving to the electronic signatures concept for mortgage documents. They thought it was long overdue.
Good. Okay. Rochelle, from the
Klamath County,
the recorder standpoint, or the electronic notarization, does your group have concerns or thoughts on this concept?
Can you guys hear me?
yes.
Yeah.
Okay. Yeah, so it's kind of a mix, but the majority of it is in favor of it. We're kind of, I mean, from other states, we're already kind of getting and seeing some of those. So we as a whole, I think, support this, go forward with it. And then we just wanted to be involved in the process is all. So.
Okay, well, we appreciate your participation, certainly in the process.
Yeah, it's nice to be here. Thanks.
Great. Has anybody kind of gone through the proposed language of the two sections, at least, or the sections that would be added to the existing statutes, to really think through how we want to do this, or?
Yeah, I guess. Generally, I think it's, I just had a few questions on a couple of areas that.
Well, this is
overall.
This is the forum, yeah.
Seemed like it was a workable situation, so.
What were your questions, Peter? And I'm looking at, what am I looking at here? I am looking at Sandy sent it out, I think, with our agenda and things.
4-page document?
Well, the
Draft amendment?
Draft amendment to 14A, and then I also sent out the final copy, which I received actually from Michael, of Rulona.
Yeah, I was looking at Rulona, but.
Well, they line up, so.
Okay,
it's all,
that's a good thing.
I think it's the 2018 Notarial Act issues memo.
Yeah,
That's right
I get that from
in the
Elaine a
document?
while back.
Yeah.
Okay. Yeah, I think that, it's all dealing with 14A, that seems to be the focus. I'd say the first part under 14A, A1A, is really, it allows the notary and a remotely located individual to communicate with each other. And it's not addressed there, but it is addressed later that the notary is located in the state. So we do have notaries that are in different jurisdictions, not just Oregon. We have, I think, about 1,500 notaries that they're located outside of Oregon, that they have to have an employer here or a place where they do business here to be a notary to qualify. But under remote notarization, does that, open it up that, well, I didn't quite get to Oregon, so, I'm just over the border in Vancouver, or we have notaries in North Carolina and Ohio, and, that's their address. So, we would just look at, should the bill be a little bit more clear that the notary has to be in Oregon when they do remote notarization. So I do that. That does get covered a little bit later in the bill. I think
it's in C.
Yeah. On page 31 of the Rulona. There was section of 14A, subsection C1C, that talks about identification of the individual. And right now, under Oregon law, it just talks about it's a driver's license, it's personal knowledge, it's a passport. So we're going to be talking about that knowledge-based test. That's not currently in the requirements of the statute. So would we be adding that as well? I think some of the other issues I had were around, dealing with identification. So I've used some services where you hold your driver's license up to the camera and it captures that, or your passport page, ID photo page. And right now, because of privacy law, we advise notaries in your journal, do not write the driver's license number. Write that it's an Oregon driver's license or the form of ID used, but don't put that sensitive information in. The fact that these are going to be captured and recorded then leads to the question, how is that secured? Is it encrypted during transmission and storage? those types of things, because now all of a sudden the notary is going to be opened up to more of identity theft law issues if that information gets breached or hacked. So, you know, our advice in the past has been just don't put it in your journal, and then, you know, it's not you avoid that issue. I think this kind of invites the issue. So then we have other questions that, you know, how do we protect the notary or make sure that the notary's using due care to protect that information?
Okay.
I think we spoke earlier about who can access the recordings, that information. I think that's the idea was that Secretary of State will cover that in Google. And those are the basic things that I have.
Okay.
Just to piggyback on what Peter was mentioning, I don't know, came out on the bill stack yesterday, which was Senate Bill 684, which deals with covered entities that own, license, maintain, store, manage, collect, process personal information. And so I was looking at subsection F and wondering if the notary has that data, are they going to be then responsible if they get breached to notify everybody, and how is that process going to work under 684? So I just want, it's a judiciary bill, I just wanted to flag that.
Okay, great. Great. How have others, Michael or Timothy, how have other states dealt with the concern of having the records hacked and having, shall we say, sensitive information in those records, or do they?
They have talked about this issue extensively, and there's essentially two different concepts that you would need to address. One is who has access to the records on request, and who should have a legitimate reason to access those records, and whether there should be, so for example, today under Rulona, a notary is not required to give over records if there's an improper purpose, but whether there should be additional safeguards with respect to the recording of the video, and whether there should be, the recording of the video itself should be confidentially kept by the notary and not disclosed or given over to anybody without consent of the person, which is the approach that Texas took in their regulations. So they've bifurcated what's in the journal, which is sort of the publicly auditable record, with the video recording, which they say is not a public record, is a confidential record that to be only turned over with the consent of the person, or of course in response to court process, summons, etc., subpoena. So that's one issue. The second issue is, how does this interact with the state's particular data breach laws? And for the most part, I've looked at a lot of these breach laws in states where this conversation has happened, and the question has arisen. And notarial acts that are being performed remotely are by definition, on the statutes I've looked at, pulled in within the existing data breach laws, because performing a notarial act remotely, you're necessarily either doing it on a fee-providing platform, or you're part of a business who's providing it as a service. So I'm a notary at a bank, or I'm a notary at a title company doing this, or at a law firm. And so all of those entities are covered by the breach statutes that I've looked at. Now, I've not looked at Oregon-specific breach statute, so that would be something to take a look at. But I would highly suspect, based upon where I've looked at in other states and where this conversation has happened, that there's probably already the procedures in place about what constitutes a breach, who requires notification, and who is the state official, probably the Attorney General, who has the authority to enforce and investigate, et cetera. So it'd be my strongly suspect that the hacking of the notary records would be covered already under Oregon law. But that is a good question, and one definitely to be looked at.
Okay, thank you. I guess I'm going to ask kind of the question: is this group generally in favor of this concept moving forward? Obviously, subject to learning about other bills going on and other information. But what's the sense of this work group to move forward in this concept to propose this kind of legislation? I open it up to y'all.
This is Cleve. For the title companies, yes, we would like to move this along. So
I think the reality is it's happening and it's going to happen. And the question is, what kinds of protections can we put in it for the people in our state?
I think our members of Creighton are asking more and more about this as an opportunity. I think we are moving around the country in this direction. So, and I agree with you, Heather. We want to make sure we do this in a proper way to have safety and soundness for consumers and especially
This is Ken Sherman. I'm just concerned a little bit about the timing. As I understood Lane's comment at the beginning of the meeting, we need to make this a one-meeting task group or task force or not introduce it in this session. And I'm just wondering, it seems like we've surfaced enough questions and concerns that it may be very difficult for us to do a responsible job of tracking all those things down and still getting a bill introduced in 2019.
And I appreciate that because I've got questions that need further information. So I don't think that we're going to go with the potential of a one meeting and work group. I think we've got lots of things that we need to address.
And I can speak on behalf of the commission. When this was initially proposed, I think there was just a lot of some hope that it would be something that could potentially get done. Just hearing all these issues, when this proposal was approved by the commission, in no way did it say it had to get done for the 2019 session. This is certainly something that could be presented for 20 or even in the future if there's enough issues. But just from the commission's perspective, it is totally okay if we flesh out all the issues. We just really want to make a good bill.
And Ken, the legislators I've been talking to, I've said this is a multi-session discussion.
Yeah.
A couple sessions.
Okay.
Discussion. Yeah, it's not something we're going to be able to do this session, I don't think.
I agree. Okay. Well, I certainly think the bankers will be supportive of the concept. They just want to approach it in a careful, responsible manner.
Yeah.
I appreciate those comments. That, you know, I think it's better to have good legislation than rush legislation.
Oh, yeah. That's definitely, the product needs to be good.
Yeah. And I think that, you know, we very much recognize this is the direction that things in the world are moving, and we need to figure out a way to be on board with that.
Okay, great. With you know, that kind of being said, it sounds like the concept has merit. We just need more information, maybe some potential drafting choices to be made. And I would anticipate that we want to have another meeting fairly soon, not not in the next 2 weeks, but
I mean, if we are looking at this like a traditional law commission work group, we would look at meeting monthly, or we can also take months off if necessary. But that would make sense, and if that's the way we want to go, I'm certainly happy to look at scheduling a meeting in February.
My 2 cents would be, and this is Ken Sherman again, we're in the middle of a legislative session right now, which is taking a lot of time and for a lot of people. And I would say, let's do some planning. Maybe if we can track down outside of a meeting some of the answers and information, like the reference to the Florida work, to get that material together and maybe take 2 or 3 months off so that we get at least through the initial part of this session, and then come together again and see where we are. I think we've got the time to do that, and I think we'll be better able to focus on this if we aren't worrying about 30 bills out there that are being acted on today.
Yeah, I think that's an appropriate way of going about it, because I think that we're going to need to gather some information and see what other legislation is doing, and maybe we'll have a bit more sense of where they're going, so.
Yeah, so I've been taking notes of all the different bills that people have been discussed or different ideas. Pamela, thank you already sent me the HB 2425, and I'll get that distributed out to the group.
And, you know, some issues related to notarization may come up during our bill discussion, because they have come up in meetings, so it might be interesting to hear if there are any issues there. And again, I expect that bill up next week sometime, not next week, the following week. You know, I agree with Ken, if we could maybe get through the first deadline for bill transfer from out of committee, that would be a better time to meet after, because then our workload.
What's the deadline now?
March. Yeah, March. Yeah, March. It's the end of March, I know that. Yeah, I know March, 29th is the deadline to schedule, work session in the Chamber of Courts. So, in the work session in the first Chamber of Courts. So, end of March. So, I would say April would be good time for the next discussion.
Okay, sure.
And I apologize for running to that.
Thank you for being here.
Yeah, thank you. We'll
Thank
see
you.
guys. Yeah, thanks for this discussion. Really appreciate it.
Okay. Well, why don't we approach it this way? We'll kind of like the concept probably, but we have questions and need a little bit more information. So why don't we gather that information, disseminate it to the group, and then schedule something for April as it's available. And then we can further the discussion and maybe get to something that we can propose here. So with that, Michael and Timothy, I certainly thank you for your very helpful participation, and you're welcome to continue to help us figure this one out.
Oh, you're welcome.
Thank you for inviting me. You're welcome.
Yep.
And I'll continue to keep you both on the list for future meetings, and anything you'd like to add and have distributed to the group, just let me know, and I'm happy to help.
And anything else for the good of the order here?
I'm gonna go ahead, I'll cancel your bill
so.
draft, and you can always,
Put it on hold. You know?
well, you can uncancel it if
Yeah.
you do it by February 20th.
I won't have.
We just
Okay, all right. Thank you. Well, I'm going to deem us adjourned then.
All right, thank you.
Thank
Thank you, everybody.
Thank you, everyone.
Great weekend. You bet.
you.